Good morning, everyone, and welcome to another Hull and Hull breakfast series. We're very pleased to have everyone with us today, actually in the house, if I can say it that way, as well as on web as well. Today we're pleased to present a program where Megan Connolly will be presenting her topic, Where There's a Gift, There's a Way, the application of the Cypre doctrine. And then also, Ian Hull and Susanna Popovic-Montag are going to be presenting their papers, but for a little difference this morning, perhaps a little jigger to the regular routine, we thought it would be nice if we could do it by way of a panel discussion involving all those at the table, but of course, more particularly, both Ian and Susanna. And again, they're going to cover off the topics that you have in front of you: the estate planner retainer, acting for husband and wife, and that is a paper that Susanna has crafted and will be mostly answering questions to, and recent case law developments for the estate solicitor from Ian. And before we get started today, I'd like to introduce those from Hull and Hull that are here with us today. First of all, Paul Trudell, David Smith, Natalia Angelini, Diane Vieira, Sharon Davis, Nadia, and forgive me, Nadia, I do have problems sometimes with your last name, Herastomovich. We also have with us, we have Rick Bickram with us, Jonathan Morse. We also have clerks with us this morning. We have Brenda Elliott, and we have Heather McGuinness. And we also have our returning articling student for next year, Genevieve Giraudet, and I believe that I've captured everyone this morning. So with that in mind, and trying to keep this on pace as we like to do, to have it finished by 9:30 with questions that you may have as a follow-up after that, I would like Megan Connolly to come up and discuss her topic with you.
Good morning. So as Craig mentioned, I'm talking about something called the Cypre doctrine. The Cypre doctrine is something that really applies only to charitable gift, and it's a way of stopping gifts to charities that would fail from failing. Now, there are a number of reasons why a charity gift can fail. Sometimes the beneficiary at the time of the testator's death isn't in existence anymore. Sometimes the charity can't be identified or it can't be located. Sometimes the terms attached to the gift are such that the gift can't be carried out. Sometimes the donor of the gift tries to give something that they didn't own by the time they died, so maybe giving real property to a charity that they later sell. And sometimes there are insufficient funds to provide for the gift that the testator wanted to give. Now, the usual rule when gifts fail or can't be made is they fail. So if a testator tries to leave a car to his sister and doesn't own the car, well, then the gift can't be made. Or if somebody leaves money to a neighbor and the neighbor's dead by the time the testator dies, that gift will fail. But when the gift's to charities, the rule's usually different. When the gift in question is directed to a charity and there's something about the gift that shows that it wasn't so much a gift to the specific charity, but it was motivated by some sort of overriding intent, then the court will step in and try to ensure that the gift doesn't fail by invoking the Cypre doctrine and trying to find some other way of applying the gifts to a charitable purpose. Cypre, it's an old, I think, Norman French expression meaning as near as possible. And the court will apply it if a gift is impossible, impractical, or sort of as a subset either illegal or against public policy. What the court will do is it will try to find a source for the gift that's going to be as close to the testator's original intent as can be. What the court does is it will read the testator's will as if the specific gift wasn't made, but that instead the testator had just provided some sort of general direction that the gifts be given to charity. And the ultimate objective, like I said, is to try to find a source for the gift as close to the original objective as possible. Generally speaking, the question that the court asks is, if given the choice, would the testator have said, if we can't find the charity, I don't want the gift to be made? Or would the testator have said, if you can't find the charity or you can't make the gift, please find another way of making it? Now, if you have someone wander into your office and you're looking at the will, and I'm talking sort of to the estate solicitors out there, and there's something, I guess, sort of ambiguous about the gift, before you decide whether it's a cypre situation, try to figure out whether that ambiguity is just about the naming of the charity, because not every ambiguity requires the cypre doctrine. There are two main situations where the cypre doctrine isn't necessary. That's where the charity is simply misnamed or misdescribed, and the second is where the charity is still in existence, either as a successor charity or through a changed form. When I talk about a charity which has been misnamed, try to determine whether there's actually any sort of genuine uncertainty as to who the charitable beneficiary is. And the uncertainty needs to be reasonable. The question is, are we really unclear here who the beneficiary is, or is there just something typographical or in misdescription that causes, I guess, some sort of mistake? The most obvious and the, I guess, frequent one I see is people who try to give money to the Hospital for Sick Children Foundation. Well, the legal name of that isn't the Hospital for Sick Children Foundation, it's the Sick Kids Foundation. But I'm guessing if most of you got a will where there was a bequest to the Hospital for Sick Children's Foundation in Toronto, you would know who that gift was to. And in cases like that, the court isn't really interested in getting to a cypre issue. They'll just say, look, it's obvious the testator wanted it to go to the Sick Kids Foundation. We're not going to waste time and resources dealing with a cypre issue where the doctrine really isn't necessary. There's no genuine question as to who the beneficiary is. You sometimes see it where it's clear who the charity should have been, but the testator just had no clue what the name is. And there was a case, I think, from the 70s called Ray Wardle, where the testator gave gifts to Catholic federated charities and Protestant federated charities, and there was no charity by either name. There was a charity called the Federation of Catholic Charities, Inc., and the court said, okay, that's obviously the charity. And its Protestant counterpart was called United Red Feather Services, which is a very, very different name than Protestant federated charities. But the court said, in this case, it's clear that the testator was trying to give funds to the, I guess, Protestant counterpart of this Catholic charity. We know who the Catholic charity is. We're going to give funds to its Protestant counterpart. This isn't a cypre issue. It's just clear that there was a misnaming. Sometimes you can do this without going to court if you get the beneficiaries to agree. Sometimes either the beneficiaries won't agree or there's still some sort of ambiguity and no one will agree on whether it's been misnamed or there's just no charity. If you have to go to court, you can use extrinsic evidence. This is stuff like solicitor's notes from when the wills were drafted, prior wills. You can also look at a prior donative history to a charity or, I guess, a history of volunteerism with your will. There's a Manitoba case where the testator had left funds to Children's Aid Society. Well, in Manitoba, there were a bunch of different Children's Aid Societies. No one knew which one it was. Two of them stepped forward. They looked at sort of the testator's history and found that over 20 years he'd given money to the Winnipeg CAS. His cousin had been the president of it. His niece had taken in wards. He'd been involved too. The court said, you know, this isn't a non-existence issue. It's clear who the beneficiary was intended to be. The other situation you see is where the intended beneficiary is still somehow in existence, only in a different form. And this is usually in situations where you have organizations which amalgamate. This is like churches that unify, school boards that unify, hospitals that unify, where when the testator made the will, the organization existed in one form. And through unification, by the time the testator dies and the gift has to be given effect, it's in another form. The main decision, or the main question that the court asks is, whether there's a continuing identity from one organization to another organization, and whether there's anything to indicate that the testator wouldn't wanted the gift to continue. If you run into the situation and you're looking for case law or anything on it, if you go back to the early 1900s and the Methodist Church, when the Methodist Church and a couple of other churches under the United Church of Canada Act amalgamated. So you had a bunch of testators who left gifts to the Methodist Church. On the time of their death, there was no more Methodist Church in their area. There was a United Church, and the court had to decide, well, does the gift fail, or do we give the gift to the United Church in the area? In a lot of those cases, they do. I found one where the court looked at the circumstances and found that the testator who gave the money to the Methodist Church really wasn't happy about the unification with the United Church. Once her church became united, stopped going, and actually, I think, converted religion. So in that situation, the court said, no, there isn't a sufficient continuing identity here. We're pretty sure that the testator, having abandoned her church, wouldn't have actually wanted her gift to go to the successor. So in that case, the gift failed. If you can get over those two humps of whether the gift's just misnamed or whether the charity's sort of changed forms and you still have a problem, start to ask whether the gift is either impracticable or impossible to make. And if they are, that's when you start getting into the cypre issues. Although saying something's impossible or impractical may seem obvious, in the case law there's not really any clear definition of either words. It's very, very fact-specific. A gift is impossible usually if there are circumstances that intervene between the time the testator made the will and the time the gift is to be made, which prevent it from being made. So a testator, for example, who gave money to a home for orphans, but by the time of his death, that home is no longer in existence. That's an impossible gift. Or if the testator had insufficient information about the charity, that it couldn't describe it adequately in the will to locate it or identify it. That's impossible. Or if the testator doesn't leave money, which sometimes happens, they want to leave money to build the church roof, but they don't leave nearly enough. That can also be an impossible gift. An impracticable gift is a gift where, although it's technically possible, it's also difficult to implement. So if someone gives money for a certain source, like paying down a debt of a church, but by the time he dies, the debt's pretty much paid, the gift isn't really practical to carry out. Or if the testator leaves money to a charity to fund fund something that it doesn't really do. So leaving money to a diabetes association to give out insulin when the association only carries on research, doesn't provide care, that would be an impracticable gift. A subset of that, and one that you're seeing a lot more frequently, is gifts where the beneficiary can't take it because of policy reasons. And you see this quite a bit with universities, where you have a testator or a donor give scholarship money to a university and earmark it for a certain purpose, for example, to further the education of women or of Catholic students or of Hispanic students. And some universities just won't accept money where it's earmarked to any sort of special interest group, no matter how disadvantaged, because they get into problems of equality, and they'll end up turning the gift down. If it's a general gift to the university, that's usually not a problem, but if it's a gift to a source where the university won't accept it, then you get into issues of how those funds can be applied. If you've determined that the gift's impossible or impracticable to carry out, or there's a policy reason, and you need to rely on the cypre doctrine, what the court will do is it will ask whether the testator evidenced a general charitable intent. And a general charitable intent is in contrast to a specific charitable intent. Specific is where, as I said in the beginning, the testator really just wants to benefit the charity. Maybe they went to a university and they leave money to that university. What they want to do is give gift to that school. If for some reason the school is no longer in existence, the court may very well say, well, there wasn't a general intent to benefit education. the church or the testator just wanted to give money to the alma mater, and in that case will be a lot more reluctant to provide or apply the Cypre doctrine and start to save the funds. A general charitable intent is where the court decides, well, the testator wanted to be generally philanthropic, and by naming this charity, that was sort of the vehicle to exercise the philanthropy. If it decides it's that sort of general sense, then it will sort of give effect to the gift. Courts are usually, I've found, especially more recently, have been very, very generous in trying to implement the doctrine. If you go back maybe 50, 75 years ago, and the doctrine goes back a few hundred years, the courts are a lot more stingy. Now I think there's sort of this policy that says, if somebody goes to the time to leave money to charity, unless it's obvious that they wouldn't have wanted the gift to be made, we're not going to allow the gift to fail, because it would sort of, for reasons of policy and equity, be unfair to the testator. If you as a state solicitor have a situation where you're dealing with the estate trustees and you're clear that the Cypre doctrine is going to become an issue, the first thing you should do is figure out who needs to be put on notice. If it's a bequest of funds and it fails, then it would fall into the residue of the estate. So the people that need to be put on notice are the other residual beneficiaries. If it's a gift of residue, then if it fails, it goes on an intestacy. So the intestate heirs have to be found, which sometimes can be really taxing. If you can find the heirs and everyone with an interest, and this includes charities who would be affected, the first thing I'd suggest doing before you run off to court is to see if you can get any consensus about what should happen. Some of the time people will say, okay, you know, obviously our uncle wanted to benefit a charity. Please, estate trustee, do whatever you can to make that happen. If everyone can get on the same side, then you don't have to start an court application at all, and you don't have to go to court. I've outlined in my paper in some detail, but the Charities Accounting Act provides for a way where you can contact the public guardian trustee with everyone's consent, get their consent, and then they'll just go and obtain the order without anyone having to go to court. If you can do that, it's going to save a lot of time and money. If people start fighting, then yes, you've got to go to court on the interpretation or the opinion, advice, and direction application, and that's where you sort of set out questions in a neutral way, asking for the court's direction as to what happens. You put everyone on notice, and you sort of see what happens. If you are going to go to court on one of that, it's best to try to make some effort to come up with a possible alternative charity which the court can give the funds to, because the court isn't going to sit there and start going through the Canadian Donors Guide trying to find a charity of their own. So try to be as helpful as if you can. My time is pretty much up, but I'll just finish by saying that if you're a drafting solicitor, you can do a lot to help this problem from arising in the first place. First of all, the testator who comes to your office may be the nicest, smartest person ever, but please don't trust the name of the charity they give to you, because they may not get it right. The CRA Charities Directorate site has a very, very exhaustive search engine. The Canadian Donors Guide sets out the legal names of most charities, and it never hurts to actually just call the charity themselves and ask how they want to be named. The final thing that you can do is consider including an anti-lapse provision in the will, which provides that if a charity ceases to exist or never exists, then the trustees in their discretion can select a charity as close to the intent as indicated by the testator as possible and give effect to the gift. Similarly, you should consider whether you want to add a provision saying, in the case the charity has changed form and there's a succeeding charity, that the trustees in their discretion can provide the funds to that charity. So I hope I've been helpful today, and I can answer questions after, and I'll let Susanna and Ian go on. Thank you very much.
Thank you, Megan, for that very enlightening discussion on your topic. And I certainly would encourage everyone to review Megan's paper on the topic. And again, those handouts together with the papers from Ian and Susanna are in the handout for everyone. Some of you have asked, and I didn't mention it before, what it was that I did to my arm. And I wish I could say that I was trekking through some exotic jungle or, hey, wait to see what the other guy looks like. But unfortunately, it was as a result of helping a friend move a washer. So suffice it to say that my days of moving furniture are over. So with that, I'll now turn it over to what I'll call a panel discussion with Ian and Susanna on their topics, and let them begin.
I always knew doing laundry was dangerous. Now I have proof, too.
I tell my wife every day I have soft hands for a reason. Sorry about that, Craig, and we all feel for you. It's been a real drag for you, I know, for the last 6 weeks with that bad wing of yours. But what Susanna and I'd like to do today in a little different format is talk about two issues that, and over the summer, we were surprised at the volume of times this issue kept coming up, and we thought we would revisit and also walk through some of the thoughts on two fundamental issues. One is taking will instructions and alerting ourselves to the question of undue influence and the kinds of expectations that the courts are going to impose at the will instruction stage. And the second issue we want to revisit is the question of joint retainers and retainers generally when taking will instructions, because there's a great, or at least there's we won't describe it as great, there's a commentary that has been added to the rules of conduct, which have really started to gel this issue, and I think it's worth revisiting, and Susanna's paper spells it out in detail. But we want to start with the question of taking excellent will instructions. And that is obviously something that we all want to do. And to be fair, we are always striving to be better at it, because whether or not we like it or not, the courts are raising the bar every day in terms of our expectations of what are we going to do to assess our client. And it's not just the lawyer, it's any of the allied professionals around. What kind of expectations are being imposed upon us at the front lines when we're meeting people to take instructions? And although the question of undue influence is not always top of mind, it seems to me that it should be much more top of mind. And I say that because we're much more sophisticated, and the courts anyway are much more sophisticated in expecting of what would come from us. I mean, years ago, my dad always tells the story who he learned at the feet of Terence Sheard. And Terence Sheard, the dean of the States Bar for many, many years, always laughed when someone said you should take notes when you take will instructions. He said, look, if I'm taking notes, then there's something wrong with the individual. And that was the mindset. And now this was the days when you couldn't sue lawyers either. So we've moved away from that now. Note-taking is expected. It's a standard of care, minimum standard of care. Are we taking careful enough notes for undue influence? Well, the answer to that really isn't how many pages you write, but the kinds of questions and the type of inquiry you're making, so that you can justify to the court that capacity, sure. I mean, the other thing is when we're taking instructions, we're most of the time, and if it's a gray area, we are insisting on a letter, a meaningful letter from a doctor. So if we've got good notes and a meaningful letter, the next layer of attack on us is, well, what kind of inquiry did you make into undue influence? So we want to talk today about what it means to have undue influence issues raised in the context of the will instructions. In our paper, the first part of the paper, we've reproduced a series of questions that my dad first developed, and we've refined them over the years. And that is a set of questions that we sit down with in front of us as dark, mean, evil gladiators about to litigate when we want to ask people who are on the front lines when we're in a trial what the kinds of inquiry they made. We have in this paper specific inquiries with regard to undue influence, and there's a heading there, not just that identifies some of the questions. I mean, this isn't just about making sure that when Betty's doing her will that the nephew isn't in the room. It's more sophisticated than that, but it's, I think, easy to identify. Using these questions as a starting point, and the next thing we want to talk a little bit about the case law. At the end of our paper, we've put a list of cases there that are really, I think, telling. And we've also put in there a series of articles that are a fun read. Some of you may not have them easy at your disposal. They're available. If you ever need them, just flip me an email and we'll send you a PDF of them. They're really I just find them fascinating because it's part and parcel of undue influence is getting inside the head of the testator And these are written by, a lot of them are written by doctors, psychiatrists, the people who are writing the retrospective opinions saying whether or not capacity exists or not. So they're fun, but they also really, they add on that extra layer of analysis. So let's just start at principle one, and that is the definition of undue influence.
And we know basically what the courts are saying to us is that you're going to show undue influence, then you've got to show that there was coercion, that there's this arm twisting, the notional, twisting your arm behind your back to make you do what it is that's ultimately been done in the will.
And the indicia of that coercion. So the term coercion doesn't really help me anyway. I think about it and I think, as Susanna says, it is arm twisting. And it is doing something beyond what the testator wants to do and the behavior that could occur. So at the instruction stage, how are we going to determine what arm twisting is possibly going on? And before we ask that, the courts have been very careful about deciding how and delineating what undue influence really is compared to influence.
And as Ian said, the questions that are set out in the paper, if you look at the questions starting at page 8 to 9 and then including page 10, you can see the kind of stuff that goes to this whole concept of undue influence, because it's not a clear thing. You can't just say, it's not something that's going to stick out to you necessarily, that this is what's being happened. It's something that depends upon the circumstances in which that individual is making that will, and it depends upon a history of the activity that's been going on before they're actually putting pen to paper.
So, Susanna, what's the difference between undue influence and influence, and how have the courts sort of helped us explain that?
Well, it's quite clear that the courts are saying, of course, everyone's going to be influenced to some extent. If you're a husband and wife and you're doing a will, there's going to be some influence. And not every form of influence or suggestion is going to be improper. It's when it's something that they call undue influence, when you've pushed the envelope a little too far, that they're going to have their backs up.
So it seems to me the first thing I want to concern myself with is this individual subject to influence? Almost always, yes. Everybody, as Susanna said, from day to day is influenced. Is it undue? So let's start looking at the kinds of indicia and the kinds of tests that we need to look into to determine that, whether or not it's actual undue influence or influence itself, and where that indicia is found. So first of all, the indicia, classic indicia, in the room when the will is being signed. All of us in this room and on the on the internet know that's a bad thing. That's a bad idea. No matter whether or not the individual being in the room at the same time should or shouldn't be there, you never get off, you never shake the smell test on that one. That's an obvious indicia. What are some of the other types of indicia, Susanna, that the cases have talked about?
Well, we've seen many illustrations, Ian, where people will use their own professionals and accountants, their lawyers, their investment advisors, and use those individuals with the testator so that there is that setting up for a possible undue influence.
So the extent that you may want to make inquiries as to what other allied professionals are involved, it's an easy question to ask when you're doing the intake, and that is, who's your accountant? Is it the same accountant as your nephew Billy? Who's your investment advisor? Is it the same? And if it is, that may trigger you to make some further inquiries. You don't know that there's undue influence typically around until you start to drill down on it. And that's why we think our questions anyway start that process. Once we're alerted, it's like testamentary capacity. You have to start. I try to start as soon as I hear the bell ringing. It's ringing in my ear. I start to drill down on it. And I'm not saying that every time a shared accountant is a problem, but it may be part of the indicia, and maybe you can at least you've canvassed it.
And you may also want to explore the nature of transactions that have gone on over the last little while. If it turns out that that person who's in the room is in fact a power of attorney, or someone who has been transacting with, in some form, the property that's owned by the testator, that might ring another bell or alert you to maybe possibly probing a little bit more about that scenario.
So, the classic scenario where you might want to set up a joint account with your dutiful son, and they come in and see you, and they say, oh, yeah, 2 weeks ago we set up the joint account. Again, that's an indicia of undue influence, or is it an indicia of influence? I think that it's worth exploring that, so that someday down the road nobody's going to turn around and say, look at you missed that one. He took over the whole bank account 2 weeks earlier, and you didn't ask about it at the intake. These are the sorts of things that, as I say, all we're doing is trying to determine whether it's influence or potentially undue influence.
And keeping in mind, of course, that it's not always going to be transparent, because a lot of transactions or a lot of these situations involve a lot of secrecy. And so you're going to probe it to the extent that you think that what you've heard so far will warrant that kind of an inquiry. Because at the end of the day, these people who do influence do it well, and they do it secretly, and then to demonstrate it, it may just be based on circumstantial evidence.
And the other classic scenario that is an element of many, many undue influence cases is the whole issue of cloistering. And what, to the extent, does the individual have in terms of physical freedom day to day? Are they entirely reliant on, or are they bedridden, or are they all of those physical ailments? Because some of these articles that we've referred to really, they talk about what the delineation is of course, is that the more vulnerable you are, the more likely it is to you are to possible undue influence as opposed to influence. So again, when I sit there and I see someone who is potentially the classic scenario of elderly or physically restricted, then I want to make some more inquiries. Say, how do you get around? Do you take Wheel-Trans? Did you ever get down to the Blue Jays games? Or those kinds of inquiries. Find out if their social life is entirely dependent on this individual. Obviously, in that context, too, the gifting pattern that the individual is instructing you on is an easy one to alert yourself with, and if there's a change in circumstances. But it is sometimes difficult if there's been a consistent pattern, and you want to, it seems to me, I don't want to get too lazy. If I get a client coming in who's just making a tweak to the will, but the prior will still wrote out, other than the niece, who seemed to be, the client didn't seem to have anything problem with, just because the prior will has written the niece out may not be sufficient. There may have been some influence that is carried on for a shorter or a longer period of time. All right, so once we've got the question of the kinds of indicia, then what we have to do is try to think about where is the evidence going to come from. And there's a great quote I want to turn to in terms of, Susanna was talking about the whole question of secrecy. Because secrecy is the element that we can't really resolve when we're taking our instructions at some level. But there's a fantastic, as only the British can do, a great quote from some few hundred years ago that barely speaks in English, but it says this. The definition of the question was asked, undue influence is difficult to prove. As colorfully put in one court, it is generally exercised in secret, not openly, and, like a snake crawling upon a rock, it leaves no track behind it. But its sinister, insidious effect must be determined from the facts and circumstances surrounding the testator. His physical and mental condition is shown by the evidence and the opportunity of the beneficiary of the influence bequest to mold the mind of the testator to suit his or her purposes. And where that, I like the snake analogy, but where I think it takes us is that in the intake stage, testing the surrounding circumstances is worth doing. It's worth doing on the testamentary capacity level, but it's also worth doing on the undue influence level. And those are the kind of illustrations we're talking about in terms of what kind of testing we want to do of surrounding circumstances. Knowing and understanding how this person is living on a day-to-day basis can be a relevant factor, worth taking notes of, and in large part, absolves you of the criticism that could come down the road, and that is, well, didn't you see the train wreck coming? Sure, they were cognitively presenting well, but you didn't know that the classic is, of course, if the nephew drove her to the lawyer's office, but we don't know much more than that. The other point I think that's worth considering in the context of undue influence is the special role the court takes when assessing these cases. And Susanna, why don't we talk just a couple of minutes about the Ettore decision and some of the comments that have come out with prior decisions in the context of what the courts are saying about why this is a unique scenario.
And the reason for that really is because a declaration that a will is valid is a declaration that is something that's held out to the whole world. So we can all rely on the finding of probate of a will. And that's a little bit different than a normal lawsuit where you've got an action just between the parties, and so any determination by a court will only bind those parties to the proceedings. And Ettore, Justice Cullity specifically said in his case, and he referred to the Ostrich decision, an older case that said that the procedure that leads to a declaration by the court that the will is the last and valid will of the person is more than just a matter between the parties. It's a declaration that can be relied on by the whole world, and it's as a result of that the court wants full evidence before it. They want to know what exactly went on. They want to test the capacity, the possibility for undue influence, the circumstances surrounding the execution. All of those things are very important because of the in rem nature of declaration of probate.
So we have this inquisitorial role that the court will take at the other end of the equation. And that's where I get most nervous, when I see a court is going to be taking that kind of active role. When I say nervous, I say that's where I can be professionally embarrassed. I can be looked at as though having not made the inquiries that a judge will be making at the trial. And that inquisitorial role enhances my my intake because of that nature. And the other side of the equation, when I think about undue influence, is the whole doctrine of suspicious circumstances, because there's a dovetailing in there, and we're not going to get into the minutia of the onuses and the triple flip of the onus that occurs, and now there's a recent decision that really questions what onus is where by Justice Newbold. Forget all of that for the moment. What is the doctrine of suspicious circumstances? Well, it is the underpinning of the undue influence characteristics, and that is if there are suspicious circumstances and you haven't inquired into when alerted, then you've fallen subject possibly to some criticism of having not undertaken the kinds of question that you should have. So let's just look at the concept of suspicious circumstances as well, because I think it too helps me alert myself to the kind of special circumstances that undue influence that exist in undue influence.
And I really see suspicious circumstances as a three-part kind of test, where you're looking firstly at the circumstances surrounding the preparation of the will. What was going on when that will instruction was being made, when the will was actually being signed? And then secondly, any circumstances that might call into question the capacity of the testator. So anything that might speak to whether or not they were mentally capable of doing what they chose to do in their wills. And then again, the third part being whether there are any circumstances that show that somehow the free will of the testator was being, maybe not coerced, but being influenced, and possibly unduly so.
And I think in our list we have the case of Scott and Cousins, and it's really in large part seen as a sort of a bit of the Bible on how the courts are to dovetail the two issues of undue influence and suspicious circumstances in there. And in that case, the undue influencer was dead and had already predeceased the deceased, and had sufficiently evidence had to be led sufficient to prove that the undue influencer, who was not alive, was an undue influencer. But that's just a neat sort of fact. But the point about the decision, where it really, I think it really helped us, is that in some respects, if you want to, if you're going to have the guts to chase down undue influence at our stage, in the litigation stage, it is not for the faint of heart. It is the most difficult case to win, bar none, in terms of subject to fraud. And so where's the source of it? The source of it is third-party evidence. Well, what's that third-party evidence going to be? It's going to be medical records. It's going to be the neighbor. It's going to be the fact that a friend saw the undue influencer screaming at the testator at a wedding or something, or threatening the testator at a wedding that he was going to be put into a home if he didn't participate, play along. Those are all third-party sources. Again, as a drafting solicitor taking instructions, how do we find that stuff out? Well, realistically, you don't find that stuff out. But what you do find out is that behavior and the type of kind of questions like, geez, you see a lot of your nephew. That sounds great. That nephew sounds like he's really being a big part of your life and an important, dutiful nephew. Do you have any sort of conflicts with him, or do you ever have any difficulties, any disagreements? Kind of inquiries, a note of that, the response to that, if it's responsive and fulsome, if it isn't, you drill down. Those are the kinds of things I like to do to really push back on it, especially when you know you have someone with the possible vulnerable, physically or mentally vulnerable scenario, and at the same time you know that there is a certain dependency out there. I'm not saying that everybody who's helping a nice elderly person is an undue influencer, and the courts aren't saying that. Most of them are saying that's an influencer, and a wonderful influencer, and a big part of that person's life. What we have to make sure we've done at our front line is make sure that's not the undue influencer. And the case of Scott and Cousins really helps talk about that. And the point is that in that case they talk about is that of course the onus on the undue influencer it's the onus is on those alleging undue influence to prove it. So there's a extra burden legally on you. One of the other things that came out of this sort of inquiry, and we're going to wrap up shortly to turn to the whole question of retainer, that is the other element of testamentary capacity. If you look at the cases, the courts say in many respects there's a three-prong expectation. One, that you have mental cognitive testamentary capacity. Two, is the individual being unduly influenced? And three, a component of that is knowledge and approval. And often we forget that, but I see the knowledge and approval element of the test as another opportunity to really drill down on the possibility of undue influence being present. So, Susanna, first of all, let's just talk about what is knowledge and approval.
Well, Ian, if you've got a capable testator, then if that testator is executing a will in circumstances where there is no suspicion that's being aroused, then we can probably draw the conclusion that they knew and they approved of what it was that they were doing. So they were capable, and there's no suspicion in terms of these circumstances. And in that kind of a situation, we as litigators have the benefit of a rebuttable presumption that says that a capable testatrix is presumed to know and approve the contents of her will. And the way that you can rebut that presumption is to raise some indicia of what we just talked about, suspicious circumstances.
And so the final thought on this is this, as from my perspective, is that with knowledge and approval, the opportunity we have is to review the will. Nobody wants us to review the will word for word. It's not realistic. Whether someday a judge tells us that we're supposed to word for word read a will, I don't know. They tend to push the envelope on our expectations every day, but I don't think that's what we're expected to do. What we're expected to do, though, is take that opportunity of the review of the will as our second layer of inquiry. So we get a chance to take instructions, send the client away, come back, and that second visit, I look at that time as my time to really hone in on the opportunity to double check my test of undue influence, testamentary capacity, and knowledge and approval. Because while I don't take the opportunity to read it word for word, I take each of those sections and I take a chance as a chance to have a dialogue on it. Easy one is appointment of executor, and take that opportunity and say, look, you've appointed your nephew. And then revisit some of the questions that you may have asked in the initial inquiry. Use that opportunity to push back again on, well, is that nephew an influencer or an undue influencer, and is this the right choice? So I've satisfied what a court might say I should have done. I've taken careful notes of it when I did it again, and what I often will do with it is I'll take my draft will that I've got in front of them and be writing notes with the different paragraphs I've gone through. I see that you've given 2/3 of your estate to your nephew. Now, let's walk through what your estate is. Again, I understand it to be X, Y, and Z. That means your nephew is going to be receiving $5 million or $2 or whatever the amount is. You take that opportunity, making some notes of it, because you push back and that opportunity again to start to drill down on whether or not you've covered the issues itself. So knowledge and approval, I like it because it kind of closes the loop. All right, we'd like to just turn to and we'll have an opportunity to have some questions on this if people have any at the end of this. We wanted to turn to and just discuss briefly this whole question of mirror wills and joint retainers and the like. Now, it's not a topic that's new to us, but as I say, I think the new, relatively new commentary Susanna and I sort of felt that it was worth revisiting it. So, Susanna, let's set this up. First of all, what kind of scenario are we looking at that we want to illustrate the new commentary with?
Well, we've got a husband and wife who've come in, they've done mirror wills, and they've happily paid your bill, they've gone home, and everything seems fine. Someday down the future, one of those partners contacts you and says they want to make a change to their will, but they don't want you to tell the other partner. And so the question that arises is, what do we do in those circumstances? As lawyers, we're in a conflict of interest. We're facing the fact that we've got a duty of confidentiality to the person who's just contacted us, and that's going to be weighed against the duty of loyalty to our former client. And the question is, firstly, can we make that change? And secondly, if we do, can we or must we tell the other partner?
And to add to that then, Susanna, let's build the scenario out two ways. The first way is that we have told at the initial instructions when we were retained jointly, we have done what we were supposed to do, and that was had them sign a joint retainer agreement and basically in written form with a follow-up letter indicated that there were no secrets. So in that scenario, how do we deal with the wayward spouse?
Well, fortunately, this is where the commentary comes in, because there was a recognition in the profession that we didn't know what to do in these circumstances and that we were being torn. And the commentary provides us with some guidance on that. And what it does is it says that, firstly, the request by one of the spouses for a change to the will is a new retainer. It's a new retainer arrangement. Secondly, that fact that you've been contacted and that request has been made cannot be relayed to the other person. And then thirdly, we are required to decline that retainer. So we can't do that unless there's a three-part condition to that. Unless the other party knows, unless the other party is dead, or unless there has been a breakdown, a permanent breakdown in the relationship so that they're no longer together.
So really the commentary has, as best it can, answered the question. When we are faced with a scenario when we have a no secrets problem, and in that we haven't set the stage for this. Ultimately, of course, good practice, and we like to do is that at the outset we've made our no secrets clear, and when the party comes to see us, we remind them that there are no secrets, and we have there are no surprises on the retainer side. All right. Well, we thought what we've done today is sort of cover two fairly meaty topics, but ones that we find come up in our practice so regularly that, and certainly on the litigation side, unfortunately, as I say, I think that the rise in claims on undue influence is there, and I think that's one of the new panaceas for challenges to wills. So if that's out there, then we may as well do our best to be ready for it in a defensive way when they're taking the instructions. Do any of you have any questions or comments about that or the mirror will scenario? Because, great, Rich.
Let's take that situation you just described and change it a little bit. Spouse comes in to you and says, you've never acted for that person.
Sorry, we're on the internet too, so they just want to.
Okay. So somebody comes to see you, says, hi, you don't know me, you've never seen me before. A few years ago, I did mirror wills with my husband, where we benefited each other, typical mirror will. Now I want to change it. And you say, well, why are you coming to me and not the lawyer who you went to before, where you have I don't want my husband to know, I don't want anybody to know, I don't like him anymore, I want to change these things. Do you have any concerns with that situation?
Personally, I have a lot of concerns with that, ethically and morally. But all we can do is sort of ride by what we are told as a profession in the rules of professional conduct. And this is exactly the situation. When I do what I'm told by the commentary, in the first situation where I've done the mirror wills and one is coming back, I know in the back of my head that they're just going to go down the street and they're going to go and see someone else who's going to do the will. Now, this is a little bit different because you're actually telling them that you've done a mirror will before. So it puts more of an onus, I think, on us to decide whether or not we're comfortable taking that retainer. But the truth is, it is a new retainer, and we are bound by confidentiality, and then it's just a personal decision, I think, whether or not you're going to take those instructions and do that will.
And I think the twist there, too, is when faced with that, again, I would want to push back on whether or not this, and really you are the lawyer down the street, right? The commentary says, if it happens, basically send them away, right? And so the scenario that you've put is that it's a great question. It's sort of closing the loop. It's like, okay, they walked down the street, they walked into the offices of Rich Evanson and said, I want to do a will. My regular lawyer won't do it. So I think at that point, one of the things I'd like to do is make sure that I've made inquiries as to whether or not there's any possibility there's a contract not to change your will that has been created in the prior mirror will scenario. And that is something that really often is underestimated. I mean, there's more and more when people are coming in to do mirror wills, you are being asked, well, do you want to make a contract not to change your wills? Do you want to make this more enforceable than just this exchange of two wills? And as the Hall decision, the Hall estate, which the court sort of said, look, even the mirror wills is a contract. you've really agreed that you're, and substantively they held that you've agreed not to change your wills, while it may not be clearly stated in the documents themselves. But in your scenario, that would be the inquiry I'd want to make, and I'd want to say in my reporting letter, this is a special scenario. I can't tell you whether or not this is going to work. To speculate, I don't think you can turn the retainer down. Well, you can turn the retainer down if you choose to, but I'm not sure you have to return the retainer down, but you have to be, I think, very careful to report to the client in writing that this may not work. So that when it comes into, and the Hall estate was exactly that scenario. They walk down the street, the new lawyer does the will, and it turned out that the mirror will document was sufficient in the judge's mind to create a contract not to change the will. So your will, the new Rich Evanson will, was not upheld. And I don't know the answer to this in that case, but I'm not sure that that lawyer said to the individual when they came to see them, don't change your will, or if I do, I don't know if it's going to work. So that would be the only other add-on that I would say in that scenario. It's a very tough scenario, but let's be honest, statistically, it's one that happens in a busy wills practice. It is not uncommon to see these scenarios pop up. We certainly see them litigated more than we'd like, for sure. Anybody else have any other questions? We thought we'd try to work in the question period before the 9:30 end time, because we know people like to get back to their office and not miss any more of their day. Sure. That'd be great if you could. We have a webcast going, which we always encourage those who are interested. That's simultaneously going on, so it'd be great if you asked a question on the microphone.
If you have a person come in who brings with him or her somebody, say you have a parent, the parent's in their 70s, 80s, the kid is sitting there, do you have a conversation with both of them at once, or do you ask the kid to leave? The kid may be 50.
It's a good question, and I think the first is always fact-specific in a sense, because it really depends on the circumstances. But look, we see the wrong side of all these cases, and so my view is exit stage left. Get that kid out of the room. And don't have the kid even within listening distance. In the sense that I've had cases where we've been litigating over, and they put him in the side room. It was a small office, thin wall, and they heard everything. So my personal view would be separate them as soon as you can, but be polite about it and firm, because you'll just never get over the burden later when the person's passed away and they're not there to say, listen, I wanted Johnny there. I needed Johnny there. I don't know how to run an apartment building.
And I'm thinking of this not in terms of wills, but in terms of marriage contracts.
Yep.
Because the tests are the same in a sense.
Yes.
You're trying to figure out whether you're getting clear instructions or not, and who's really pushing the best. So let's take that scenario.
Sure.
Let's take the 50-year-old kid out of the room.
Yeah.
And then you start to converse with the parent, who may or may not have lots of money, probably has money. And then it appears that the parent is kind of in and out of lucidity. They're letting you chat it for a couple hours, trying to figure out what's going on.
Sure.
What do you do then? You might say to the parent, would you actually send one of your own clients out to have their capacity assessed?
Without hesitation.
Really?
Absolutely. Because the point I say to them is this: look, I'm not helping you. I can't fix this problem. You need me to do this right. I need to belt and suspenders this. I need someone, because all I'll do is create a document that doesn't mean anything. And it's only to your advantage. And it's, I mean, look, maybe there's a certain amount of self-preservation in that comment there for sure, but
No, I feel it too. We're on the same page.
yeah, it's just, but it doesn't make any sense. Clients come to see you to get service. And if I'm not fulfilling that service by saying we're opening ourselves to a can of worms. I mean, I think it comes back to the same point too. Is when clients come to say to you, I want to cut someone out of the will, even if they're lucid, I say, okay, no problem. Take a deep breath, because I'm writing down right here, no matter how hard I try, this could be a mess after you die, right? And it's the same scenario there. It's like, if you've got some lucidity issues, I've got to make sure that I do this right. And so you push it back onto the client because it is for the client's benefit.
All right. One more thing, because
Yeah.
this actually comes up and it makes me really nervous.
Sure.
So then the capacity assessment comes back, and it's kind of okay, it passes. But then when you're talking to the person, you know they're really not. They're in and out. So they might have a good day, bad day, good
Yeah.
for a couple of hours, bad for 20 minutes. So what do you do about that? Then you just keep forging ahead? Or then do you talk to perhaps, I don't know, what do you do?
Well, it's great. You know, it's a great question, and the answer nicely is solved by Justice Cullity and Scott and Cousins. Thank goodness, because what do I know? But the truth is that you have to accept. First of all, and he says it right in the decision. We're lawyers, and we're not God. We can't play God in that scenario. We have to take instructions, and we have to do our best in circumstances that are put to us. And so, essentially, he's saying, Scott and Cousins, good days and bad days. You've got to pick your moment. You may have to say, look, I'm going to have a couple of visits. I may have to come back and we'll have to see each other again. But ultimately, it's not for us to be the final arbiter on whether or not they have capacity. All we can do is our best to document what we think or not think. If they're clearly not lucid, there's a big debate out there. Probably not draw the will, but they have to be clearly not lucid. They have to fall into that clearly not lucid stage. And have you gone back and tested it? Because you could be criticized that was a bad day and you should have done the will the next day. And the second thing is close calls are close calls, and that's ultimately what the courts have to arbitrate.
Thank you.
Or adjudicate. No arbitration at that level. Thank you very much. Stan.
If you feel there is undue influence, but you also feel that the testator knows that this is what he wants to do, would you decline the retainer?
Good question. I mean, really, that comes down to the fundamental question of it: is it influence or is it undue influence? And if it is close, do you accept the retainer or not? I mean, if it's clearly undue influence, and there is, I had a case once where the lawyer said to the nephew, "Get out! You've got to leave the room," and he wouldn't. And so the lawyer drew the will, took careful notes, and said, I have told the nephew not to be here. I've told the client that the nephew should not be here. I've told him that this is going to create, guaranteed, a lawsuit and an allegation of undue influence. And he still drew the will, because it comes back to the same thing. He wasn't going to play God. He wasn't going to say that I'm not going to let you, accept your testament, your wishes. That's a bit of an extreme example. When it comes right down to it, we're supposed to take instructions from people who have capacity, and part of capacity is whether or not they're being compelled to do something different. So, I don't know. I mean, Craig and Suzanne, I don't know. It's a really it's a tough in the gray area where whether or not you draw the will or not. But ultimately, again, I keep coming back to the Cullity words: is that it's a close call. We're probably expected to draw the will, because Hall and Bennett was pretty tough on us in the Court of Appeal about a lawyer who didn't draw the will, in a scenario that was similar. I don't know what you think, Craig or Susanna. It's a good question, though, Stan.
No, I would agree with what you just said, Ian. I mean, the difficulties arise, too, that if you don't draw the will and there's issues with medical health, the person has capacity, but there's issues of health, and then they pass away, and then someone comes back and says, why didn't you draw the will? Those are all issues that come into bear when you're dealing with that individual, because again, the scenario that Ian is most likely referring to is someone who is elderly and more than likely needing the care of others to get by on a day-by-day basis. Doesn't mean that they're not mentally capable, but if they're not capable of taking care of themselves physically, how is that playing into the situation, and how does frankly, their lifespan are things imminent to deal with these kinds of issues. And so that is another complicating factor, but I certainly agree with Ian with his comments.
Me too. I think it's all about, ultimately, the self-preservation. And if we're told we're not God, we can't make those determinations. We've got to document our investigations as much as possible. And then I'd take it one step further and also report that as well in the reporting letter, just so that you've covered off the full gamut.
I think the one thing that I've learned in this practice in my short years compared to my dad is that you cannot predict the Grim Reaper. And every time I think, wow, nobody saw that death coming, you just can't, and you can't tell. And so ultimately that comes back to Cullity's words. It's like, you know what, we're here, we do our best, we do what we have to do in terms of our intake, and we probably generally have to draw the will and ultimately accept the obligations that come with this. The only problem we are all doing that is very frustrating is that we're not charging enough for the burden that we are taking on for that moment, because lots of them work, but it's just need a few that don't go so good to create a big headache. All right, well, what we're going to do is we'll let Craig wind things up, but we want to make sure people stay on track for the day.
Thank you again, everyone, for coming out to the breakfast. If you do have any questions, please feel free to stay. The formal part of the program is now ended at 9:30, so feel free to leave. But if you do have a question and it pertains to what we talked about today or not, please feel free to ask it. I would also encourage everyone to come to the website at Hull and Hull and check out the podcasts and the blogs. The podcasts on a weekly basis and the blogs on a daily basis. You may find some useful information, or hopefully you will find useful information, both in those and also available on the website. So again, thank you very much, and we'll see you the next time.